Welcome to Brief Encounters and another episode of the Securities Regulation and Enforcement series. My name is Valerie Mirko. I'm a partner at Armstrong, Teasdale, and I also lead the firm's Securities Regulation and Litigation practice. And with me is my co-host, William Nelson. William, will you go ahead and introduce yourself?
Yeah, absolutely. And thanks, Valerie. And excited. Another episode of the podcast. I'm William Nelson. I'm the Director of Public Policy and Associate General Counsel at the Investment Advisors Association.
And William, last month when we finished recording our April episode, Chair Atkins had just been confirmed by the Senate. And we thought that by the time we recorded our May episode, he would have been sworn in and in place. And we did turn out to be right. But a lot has been going on, as we've been saying in all of our recent episodes concerning the transition within the SEC. So can you kick us off and tell us sort of what is the latest news 2 weeks into Chair Atkins's term?
Yeah, absolutely, Valerie. And it's shocking that it's only been 2 weeks. He was, he started his tenure at the SEC April 21st. But even since then, a lot has happened. And it's funny, I actually made a joke in the last podcast about white smoke, and now we have a new pope as well. So I think going forward for the SEC, and what's interesting is that, Chair Atkins recently held what he called a town hall. It was internal for the staff, but he did put out a public statement, kind of outlining his policies, outlining his priorities. Not surprisingly, it's a refrain we've heard from a lot of the staff, a lot of people in the industry, kind of back to basics, return to the core mission, investor protection, capital formation, market efficiency. But I did want to point out a few kind of notes that I saw from his statement that I think would be, of interest to our audience. I think the first is that Chair Atkins did confirm a lot of the public reporting we've seen that there has been a 15% reduction in headcount at the agency. Again, I think that, in past administrations, there's always going to be turnover. Some are more policy political positions, some are more staff positions. But I think, this in change of administration, I know we've talked about this before. I think this differs in a few ways. I think the first is that generally this happens over a period of a few years. So, we might see a large reduction in headcount over 1 year, 2 years, 3 years. But this happened in a matter of months. So again, I think that's, the timeline is pretty drastic. The second is that I think that one of the big differences in this administration, especially with the voluntary retirement program that they offered, was that they've lost a lot of seniority. I think, in talking with people at the SEC, talking with people in the industry, we have heard that, a lot of the staff that has left were in senior positions. So I think there is that kind of, intellectual piece to it. They have the institutional knowledge, they have that seniority. So it is going to be interesting to see kind of, how the SEC deals with that over the next, coming weeks and months. How will they fill those positions? I know there's a hiring freeze currently, so I don't know if they can go outside the agency, but it'll be interesting to see how they're going to kind of fill those positions internally. I think another note I would make is that we've seen a lot with the DOGE effort, the Department of Government Efficiency, related to government buildings. And one of the reports we saw was that, hey, there's going to be this restructuring in the SEC regional office, kind of organization. And it was interesting because Chair Atkins in his town hall talked about his support for the regional office model. He believes that he should have boots on the ground in these different regions. Not everyone should be based in headquarters, but at the same time, did note offices like Los Angeles, the Philadelphia office, kind of still need to be dealt with. So I think we are going to see, I don't know, a whole organization, but I think there will be, some changes at the regional office level. And I know, Valerie, you had heard from some folks as well about kind of how the regional offices were being reorganized.
No, that's exactly right, William. And I've actually worked with the regional offices quite a bit when I was at NASA because there was really strong regional level coordination between SEC offices and the states. And actually, since coming back to private practice, a large number of my enforcement matters have been opposite regional offices. So I do have a pretty good sense of the structure and how it's evolving. I think the reality is, and you've just confirmed that with Chair Atkins's comments at the town hall, there is a necessity to have a regional structure at the SEC. I think the concern and what Chair Atkins is, seems to be problem solving for is how to make sure that there is actual uniformity in terms of regional initiatives. And we've talked about that in past episodes where certain regions are going to focus on certain things based on the markets they're in. I think the example I gave was innovation and technology in California, things like oil and gas and various, like the Denver office and the Fort Worth office. Those things still matter, but how can those regional initiatives and market driven priorities be aligned in a coordinated fashion with the rest of the SEC in terms of how business is done by the regional offices?
Yeah, and those are all great points. And one thing, to your point, Valerie, we did hear, they're still going to have kind of those specialized units, whether that's private funds, technology, cyber, crypto, those kind of specialized units. But before we leave the kind of SEC organization and structure, another interesting note is that currently with the onboarding of Chair Atkins, we're currently at a 3-to-1 Republican commission. Having Chair Atkins, Commissioner was acting chair and now Commissioner Mark Ueda, and also Commissioner Hester Peirce on the Republican side, and we still have the Democratic Commissioner Caroline Crenshaw. Now, Commissioner Crenshaw was renominated. She never got a vote in the last Congress, unlikely to get a vote in this Congress. So her term has ended, but she's able to serve for up to 18 months after that end of term, and that would be the end of 2025. So at least as of the end of 2025, I think we'll still have that 3-to-1 split, the 3 Republicans, the 1 Democrat. But interestingly, after she rolls off, we've heard that President Trump does not intend to nominate any Democratic commissioners. So at least as of now, our thoughts are it will be a 3-to-0 Republican commission, at least for that year, from 2025 to the end of 2025 into 2026, when Commissioner Peirce's term ends. So I think that will be a really interesting dynamic, with Crenshaw still being on through the end of 2025, but then having that 3-0 commission, likely at least for a year.
And that is a departure from what we've seen in past administrations, although maybe not wholly unexpected in light of the executive order about independent agencies and commissions that we've discussed in past podcast episodes. There is a history of a commission being only 3 commissioners. And William, when you and I were preparing for today's episode, we did talk about that. It was just a few years ago at some point in Chair Clayton's term. So there is a history of that. There is perhaps less of a history of a 3-0 with just one party commission. And that's only sustainable through the end of 26, because at that point, Commissioner Peirce's term will indeed fully end. And there is a requirement to have a 3-commissioner quorum to vote on matters and so forth. So I expect we will pick those topics back up as things evolve over this year and next year. But I'm glad you flagged that. I did want to shift to crypto and digital assets because, of course, that has been a core part of Chair Atkins's path towards, becoming chair of the SEC in this administration. And even before Chair Atkins was confirmed and now sworn in, when Mark Uyeda was acting chair, he actually worked really quickly towards unstifled innovation and a clearer regulatory framework for cryptocurrency and digital assets. So we've talked in past episodes about the Crypto Task Force being put into place. Obviously there's still a strong anti-fraud point of view as well in terms of what this current SEC is doing, or this current commission, how they're approaching crypto. But what other recent developments have there been, William, regarding cryptocurrency and digital assets?
Valerie. Yeah, absolutely. And you're absolutely right calling it a priority, both for the administration, but also Chair Atkins. I believe he talked about it at his confirmation hearing. He talked about it at his swearing in. And he also noted that it was a top priority during that recent town hall we were just discussing. But yeah, so I think for the SEC going forward, you're absolutely right. Acting Chair Uyeda worked really quickly. They actually put out 3 different pieces of guidance. One on meme coins, when those are securities and when they're not. They also put out guidance on mining crypto, when that would be an action that would potentially come under the securities laws, and also providing guidance to digital asset and crypto companies when registering as a security, those offerings, how that would be different for a company that's in the crypto or digital asset space. They've also, you touched on the Crypto Task Force led by Hester Peirce, who has been called the crypto mom. She's been leading this charge. I think, obviously she's been leading it for years, but now with this change in administration, she's really begun to be able to delve into a lot of these topics. The first roundtable, I think, is going to be one of the most pivotal, whether crypto assets should be regulated as a security. They had a second roundtable, how to trade crypto assets. Should that be any different than, trading equities, trading fixed income? A third, and this is something, Valerie, I know you've worked on before, is, a whole roundtable on how to custody crypto assets and some of the risks arising from that.
No, I think that's exactly right, William. And it's been fascinating to watch these roundtables and also just monitor the thought leadership around them, because what we're really seeing is very, very smart people grappling with a set of issues that have remained unresolved at this point for, call it, 5 to 8 years. And some of the reasons they were unresolved were because of prior policy positions in Chair Gensler's SEC era. But some of the other reasons they remained unresolved was these are just really novel ways of thinking about how to approach securities, as well as the concept of what is a currency. But the other thing that I'm finally seeing injected into the digital assets discussion is the concept of an investment company. So to back up, for years, the topic has really been is, are digital assets currencies or are they securities? But as you start delving into the securities analysis, I've always thought it was really important to think of it also through the investment company perspective, which I did not see as much in past years. I've seen that become more part of the dialogue in recent months, and particularly in the crypto roundtables. What's interesting to me about the custody piece is fundamentally having a way to safeguard digital assets, whether you think they're currency, commodities, investment companies, or securities or securities. The most important part from an investor protection perspective is how to safeguard them. And there was a significant amount of guidance preventing broker-dealers from being part of the custodian safeguarding framework for crypto And that is finally, I think, being re-examined. I did a fair amount of work on crypto custody from sort of 2021 until now. There was always this sense of, well, what type of financial institution is best suited to safeguard these assets? And the parallel that I'm going to make is there's certain private securities and private fund assets that are sometimes a head scratcher in terms of how to custody and safeguard them. I'm seeing some commonalities between some of those issues that I've dealt with investment advisors and private fund advisors for a long time, and some of the questions that are coming up in terms of safeguarding and custodying digital assets.
Yeah, and I think those are all valid points, Valerie. And I think the one point you just made a few minutes ago, that this is a really difficult issue. And that's why they're having these roundtables. That's why they're getting all these, really, really smart people together. But I think in terms of custody, I think you're right. I think historically we have had this kind of binary look at, is it currency, obviously, being used as a medium of exchange to purchase goods or services, whether it's a security, obviously, whether you use the Howey test, maybe if it's more on the, staking lending, could it be a note that would also qualify as a security? But I think you're absolutely right in that we're starting to see a lot more variation, especially in how these products are brought to market. Obviously, could be commodity, so that's why the CFTC would be involved. Whether it's a company, obviously that would involve a different statute under the securities laws, the Investment Company Act. So I think going forward, these are going to be a lot of difficult issues. And just the nature, too, of the technology being this immutable distributed ledger, and how do you custody something like that? And we've heard, these stories about, people that lose their private key to a wallet, and they can literally never have access to that crypto again. So how, do we have, private keys in multiple places? There's called multiple signature, multi-sig wallets, where you need multiple authorizations to access those cryptocurrencies. So I think going forward, I think, one issue, obviously, that threshold, is it a security or not, is that obviously gets the SEC involved. But at the same time, if you're an intermediary, like our, the IA members or advisors, if you're a broker dealer who potentially has custody of crypto assets, regardless of whether it's securities, you need to make sure that you're complying with the different rules to make sure that you are protecting those certain assets. And I think we've also seen recently a big push from the prudential regulators, guidance from the OCC, guidance from the FDIC about how banks can hold cryptocurrencies. We saw the SEC withdraw their staff accounting bulletin number 122, called SAB 122. Basically, those certain accounting standards, how you have to hold crypto on your books. So I think this issue of crypto custody is going to take some time to resolve. And one question, Valerie, that, I've heard is that, is the SEC just going to focus just on, hey, let's figure out how to make rules around how to custody crypto assets? Or in the alternative, will we see, again, I know they proposed their safeguarding rule, will we see a reproposal, a much broader, kind of safeguarding custody rule, but also includes the custody of those crypto assets?
No, I think that's exactly right. And what we're seeing is a very thoughtful, holistic approach to crypto and digital assets. And I think you raising Staff Accounting Bulletin 122, which rescinded Staff Accounting Bulletin or SAB 121, is a really good example of the current commission and the staff at the commission's direction really thinking through existing frameworks and how to broaden them to reduce operational barriers for financial institutions offering crypto and digital assets and services around them. I do think fundamentally, before we move on to public companies, which I do want to touch on, But fundamentally, I think what we're seeing is a very thoughtful approach to meeting the market's demand. There is a market demand for crypto and digital assets as an asset class. And, we talked about it back in our first episode of 2025 with Pete Driscoll. And we've really been discussing that ever since. So I think we'll see a lot with crypto. And we're saying crypto, but it's really digital assets in a broader way. There's at least 3 more roundtables scheduled. I think they've been extremely well done in terms of the thoughtfulness and deliberate, almost debate, and looking at it from a very holistic point of view. But moving on to whether the SEC is only going to focus on crypto and what is going to happen with a custody rule and so forth, I do think the Gensler era custody rule was very ill-advised. It tried to shoehorn crypto into the existing IA custody rule while changing the IA custody rule materially. I think what we're more likely to see is some relief in terms of who can custody, what types of institutions, including broker dealers, can custody a crypto asset. I think that's going to be the starting point before I think we'll see any kind of wholesale rewrite of the IA custody rule. What do you think, William?
Yeah, and that aligns a lot with what we've heard as well, Valerie. We do have these few companies now. I think only 1 or 2 have actually been approved, these special purpose broker dealers that are specifically geared towards digital asset custody. I think that, if the SEC does want to move forward in this area, it would be a much easier lift to just address, these types of assets rather than trying to, again, repropose that, very large, comprehensive safeguarding custody rule, which, as you pointed out, did get a lot of pushback from the industry. So I think, it's kind of TBD, but it will be interesting to see how it plays out. But I think that, switching gears a little bit from something else that Chair Atkins has, even from his previous tenure at the SEC and throughout his career, he has had a real focus on how the SEC should treat oversight of public companies, especially when it comes to disclosure. So Valerie, I was hoping you could kind of, talk about that a little bit, especially since, initially and ongoing, this podcast, is, a podcast about Dodd-Frank, 15 years on, kind of what we're seeing. And, I think that definitely, especially in this case, really, comes up with respect to how Chair Atkins views the public company.
I think that's exactly right, William. When we launched this podcast, we were looking at discrete securities issues or Supreme Court decisions or regulatory developments through the lens of Dodd-Frank, because a lot of what has happened in recent years can be tied back to Dodd-Frank. And then at the end of last year, we started entering sort of this, presidential transition and then SEC transition phase. But fundamentally, many of the developments we're speaking about, other than, I would say, digital assets, often tie back to Dodd-Frank in some way. Here, Chair Atkins has been, over the years, fairly critical of the Dodd-Frank impact on public companies, particularly in terms of the SEC then, under the mandate of Dodd-Frank, having to put further disclosure burdens on public companies. So I do think we will see a review of public company disclosure rules that had been put into place pursuant to Dodd-Frank. I think we'll also see a reevaluation of Regulation SK. There's been an ongoing concern through, Chair Atkins' past thought leadership when he was in the private sector. He's expressed concerns about whether public companies or just companies in general are discouraged from accessing public markets because of this disclosure burden. I think, we've already seen the end of the climate disclosure rules. I think we're going to see further initiatives to reduce the disclosure burden on public companies. However, in terms of what I'm going to call sort of the capital formation / corporation finance component of SEC priorities under new Chair Atkins, I think it's going to go beyond the disclosure burden on public companies. I think we'll also see scaled back reporting obligations for emerging growth companies, possible reconsideration of the definition of accredited investor to facilitate early stage capital raising. There's been discussions around Reg A in recent weeks. So I think this is going to be broader than just alleviating the disclosure burden on public companies. And I do think also this current SEC, now that Chair Atkins is in place, I think we're not just going to see relief in terms of crypto and digital assets. I think we're going to see certain changes that alleviate burdens on public companies and private companies in terms of capital formation and disclosure more broadly.
Yeah, no, and Valerie, I think that's absolutely right. And just again, looking at his, former tenure, looking at his public comments, I think there is going to be, this is very targeted focus on how much disclosure, what's the value of that disclosure, whether we go back to definitions around materiality. You mentioned the climate disclosure rule that the SEC has basically said they're not going to, support in the courts anymore. So I think it is going to be a pretty, drastic change from the Gensler tenure around how public companies are treated and what they have to disclose to investors. But I'd also, we'd be remiss if not to talk about kind of switching gears again, but, there's been a lot coming out of FINRA lately. And I think one of the topics I know we wanted to discuss was their, kind of recent changes to the outside business activities, what the registered representatives and the FINRA member firms have to report, but also kind of this, in line with the new administration, in line with the new SEC, this kind of, process to modernize, as they say, their regulations and rules. So I don't know if you could talk a little bit about that, Valerie.
I'm so glad you brought up FINRA because, we talk about including more FINRA developments in this podcast series. And there is certainly a lot to touch on today. So since about mid-March of this year, we've seen several FINRA rulemaking initiatives that are focused on broadly modernizing FINRA rules, facilitating capital formation, modernizing their rules more generally with regards to their member firms, the broker-dealers, as well as associated persons of broker-dealers. And then finally, the outside business activity proposal, which you referenced, which, looking just at the title right there, I think says a lot about the direction that FINRA is taking. What we've all been calling the OBA proposal is a request for comment on a proposal to reduce unnecessary burdens and simplify requirements regarding associated persons' outside activities. From my perspective, I work with dual registrants as well as SEC registered investment advisors. So from my perspective, I think this update to outside business activities requirements is a welcome one. I really like that the proposal looks to decrease notice to broker-dealer firms for outside business activities that are unrelated to investing. In effect, the proposed rule would narrow the reporting obligations that currently exist, make them lighter, because the solely activities that are investment related would need to be disclosed to broker-dealer firms. And there's also a real reset around, looking at the concept of a registered person who is generally client, customer facing versus an associated person more broadly. So I think the proposal is very well done. FINRA actually included a very effective flowchart to illustrate how the proposed rule would be applied should it be adopted. And there's also a hypothetical scenario comparison that demonstrates sort of how something would be disclosed in the current state rule versus the proposed rule. So I thought it was very well done. But interestingly, there's been enough confusion around the proposal that FINRA put out a statement to, quote, correct misinformation about FINRA's outside activities proposal. And it notes in the lead paragraph of this statement that unfortunately several recent statements published in news media mischaracterized FINRA's proposal in a number of ways. And William, I was trying to think of another time that during a comment period at FINRA, there's that kind of corrective statement put out, and I really couldn't think of one. And it's certainly not something we see with SEC proposals for rulemaking either.
Yeah, and you're absolutely right, Valerie. I know generally during the open comment process, they're actually generally very tight-lipped.
Absolutely.
Because obviously everything goes into the rulemaking record, but at the same time, they don't want to bias any of the commenters, but at the same time, they don't want to basically telegraph where they're going to go with it before they receive those comments. Yeah, I thought that was pretty, I don't know about, you don't want to use the term unheard of, but I thought it was surprising that they came out so forcefully. Yeah, unusual, I think is a better word. But maybe again, like you said, Valerie, I think they were surprised at the level of comment and kind of, pushback from the industry. Yeah.
Especially since, many of us who have looked at this proposal think it's very well done. It actually does what it sets out to do, which is narrow the OBA reporting and evaluation burden for firms. Now, of course, this is a FINRA proposal and it applies solely to broker-dealers. But in practice, outside business activities is something that investment advisor firms also supervise, because the core policy reason to look at outside business activities is undisclosed or unidentified conflicts of interests, making sure that those are surfaced, as well as whether any of those activities could have the potential for additional investment related activity that is not supervised through the firm, whether it's the broker dealer or the investment advisor. So even though it's a FINRA proposal and it only applies to broker dealers, the concept of supervising OBAs is very much part of an investment advisor's 20647 requirements and toolkit. And then, of course, for dual registrants, many of these firms run OBA programs across the entire firm without really focusing on whether the person associated with the firm is solely registered as a registered representative of the broker-dealer or solely registered as an IR, or is dual-hatted in terms of their registrations, which in industry parlance is, are they a 7 and a 66, a 7 and a 65? Are they just a 7 and a 63? That type of conversation. So, in practice, we see OBA requirements for investment advisor representatives in terms of how firms supervise them. And then, of course, both IRs and registered representatives all use the same uniform Form U4.
Yeah, and I think we'll, Valerie, we'll just kind of have to see. I believe the comment period ends, I want to say May 12th. So I think we may kind of find out, sooner rather than later, kind of ultimately how, FINRA ends up, do they change the proposal based on the comments? Obviously, they'll have to take those into consideration. But yeah, it will be interesting to see kind of the final when it comes out, just based on everything we've already seen.
And, as with any comment period, William, we'll see some generally supportive comments about the narrowing of the OBA reporting burden, so to speak, and disclosure burden. But I'm sure we'll see some very thoughtful industry comments that seek to further optimize the OBA proposal and the proposed rule language to further lift some burdens off the broker-dealer industry.
Yeah, and I think you're exactly right, Valerie. And just, anecdotally, as a former chief compliance officer, I do remember times when people would come to me and say, hey, I coach my kid's soccer team. Do I have to report this as an outside business activity? Or, some of the, so I think the intention here definitely is that reduction in reporting, especially when it has nothing to do with what they're doing for their job.
No, I think that makes a lot of sense, William. And while we're touching on FINRA developments, this one's actually really interesting to me because it has an enforcement nexus, which is that on May 8th, Robert Cook, who's president and CEO of FINRA, and Greg Rupert, who is the EVP for member supervision at FINRA, put out a statement entitled SEC Off-Channel Communications Settlements, SRO Collateral Consequences. And I think they did just a really nice job in terms of offering some relief to firms that resolved off-channel communication cases with the SEC prior to 2025. These firms, many of which were broker-dealers, also had to put into place heightened supervision plans, HSPs. And there were pre-2025 settlements that came with these heightened supervision plans or HSPs. Then there were the settlements that happened right at the end of Chair Gensler's tenure in 2025. There was also a group of firms that settled before 2025 that petitioned the SEC to modify their settlements to align with the January 2025 firm settlements. The SEC recently denied that petition. So while I think we can all agree that off-channel communication is no longer a case theory used with an extremely heavy hand by the SEC, while those days are past, we are very much in a phase where the firms that did come to settlement for off-channel communication are dealing with the SRO collateral consequences, the lack of uniformity between the pre-2025 settlements and the post-25 settlements. So I thought this FINRA statement on SRO collateral consequences for off-channel communications was really well done. It's a very complete statement, and it notes both the importance of compliance with applicable record-keeping requirements, including in the context of OCCs, but also taking up the very complex question of how to approach collateral consequences for SRO memberships in what has at this point become a unique situation in terms of the collateral consequences of off-channel. So, as I mentioned, I thought the FINRA statement on collateral consequences for off-channel communication was very well done. It's a very directly written statement, which I always appreciate from a regulator. And it makes very clear that there is only so much FINRA can do. So, for example, it notes that any changes to these heightened supervision plans will not put pre-2025 settling firms in the same position as firms settling in 2025, and that FINRA cannot make those changes because of the differences built into the SEC settlements. It also notes that under applicable rules, FINRA cannot eliminate the HSPs altogether for the pre-2025 settling firms. But this is the part I really appreciate, where the statement goes on to say, there are several reasons why it would be appropriate in the special situation presented here and consistent with the public interest and investor protection to, and this is the key word, modify the heightened supervision plans for the pre-2025 settling firms in a manner that would bring the two sets of firms, meaning the off-channel settlement firms from pre-25 with those in 2025, essentially making an effort to bring the two sets of firms closer to alignment in terms of ongoing and essentially future obligations as SRO members. And it lists several considerations that are very facts and circumstances and fairness based. But the punchline is really that FINRA staff is working on standardized amendments to heightened supervision plans that would apply to all pre-2025 settling firms consistently. And then as part of the process, FINRA will consult as necessary with other relevant SROs, because of course, while we're talking about FINRA here and collateral consequences, there's broader collateral consequences for broker-dealers who are members of other SROs. And I just thought it was very well done. It acknowledges the complexity of the issue. It notes what FINRA can and cannot do, and then it moves to a very unique solution to a unique issue in a very thoughtful way. So I thought that was very well done. What's interesting, to bring it full circle, William, is that at the end of the statement, there's a note about modernizing rules more generally. So I think that really is modernizing FINRA rules, that is. So I think that's going to continue to be a theme out of what we see in terms of FINRA regulatory releases in the near and medium term future.
Yeah, and Valerie, I think you're absolutely right. And that really does align, again, with the SEC, the administration. They really do like to, talk about, and I think it, kind of goes to, the different phrasing, the modernization of regulations. We don't have to call it, deregulation. We're just modernizing these regulations to, match the current industry. So I do think that is interesting, but I think there will be a lot of work to be done. But I think FINRA, as you noted, I think will be, involved in that process, just, kind of seeing that, especially for these duly registered firms, those settlements can have a really big impact on, their obligations to FINRA as well.
No, I think that's exactly right, William. And I will be interested to pick this topic back up in future podcast episodes, because it is such a unique set of facts and circumstances.
Absolutely. Well, Valerie, I think we're, definitely coming to the end of our time. I feel like these last couple of months have felt more like years, and, these podcasts, I think it's interesting just to see, how much, is coming out of this administration, both regarding, operational issues, but also, substantive issues as well. So I think, coming up in the summer months, I think it would be helpful to give a little preview. I know that we are going to be talking about artificial intelligence with some really, really sophisticated folks. So really excited for the next few episodes to start diving into that topic.
Me too. And I think we'll keep diving into artificial intelligence, but also digital assets and crypto. And later in the summer, we're going to do an in-depth dive on public company developments and capital formation as well. So lots to come. And, eventually, I think we'll also be able to tie things back to Dodd-Frank a little more than we've been able to in past episodes, although we did today. So I look forward to our future episodes, William, and I will talk to you next time.
Absolutely. Thanks, Valerie.